a teenage boy was allegedly kept in an 8x8 room in a garage for several years by his adoptive parents. Timothy and Tracy Ferriter were arrested for aggravated child abuse and false imprisonment after one of their adopted children was reported missing.
Okay, so I have completed the background research on this one, and it is going to be tough. This is mom and dad. They are accused of keeping their adopted son locked in what has been referred to as a box in their garage for a very extended period of time. They're officially charged with aggravated child abuse, false imprisonment, and neglect of a child. This all came about when a contractor went to the Jupiter police and described to them this room inside of a garage that he was asked to build. It had unfinished drywall for the walls. It was a bare concrete floor with an indoor-outdoor rug on it. There was a Ring camera mounted in the ceiling, a light switch on the outside, and the door knob and lock were on the exterior. Right around the same time, a 13-year-old boy went missing. The boy was said to have behavioral disorders and was having trouble at school. They thought that's why he was missing. So 2 officers went to the home of the parents, the Ferriters. They were not home the first time they went. They went back a second time, and the wife was home, but she said she didn't feel comfortable letting them in the house without her husband home. After a long conversation, she agreed to let one of the officers in, but not the other. So that officer went in, looked around, and that's when he discovered this room. He made note of everything, didn't find anything that he thought would help him locate the child, and ultimately left. The following day, he received a notice that the child was seen near the school campus. They ultimately located the child at the school campus and brought him in for questioning. They confirmed his identity, and they discussed his living situation with him. According to the police report, he spent the majority of his time in his room. He would wake up in the morning, be in his room until one of the parents returned home from dropping the other siblings off at school. He would be fed breakfast, which consisted of a banana, a piece of bread, and peanut butter. And then when he was finished eating, he'd go back in his room, get ready for school, go to school. When he returned home from school, he would go back into his room. The child mentioned that he did not feel safe at home, and that it's redacted, but I assume he's talking about one of the parents, would get really aggressive towards him, and that they had slammed him against the wall by the neck and struck him in the face with an open hand. When asked how often it happened, he stated that it happened a lot more in Arizona.
Hey, tonight, WPBF 25 News got a hold of exclusive documents that reveal that couple's past encounters with Child Protective Services when they formerly lived in Arizona.
We learned deputies in Arizona reported the case to the Department of Child Safety. A 14-year-old runaway saying his parents were spanking him with a leather belt and a jump rope. Similar allegations to the ones he made to Jupiter Police.
We just obtained the Pima County Sheriff's Office reports documenting 2 investigations. Pima County deputies in November 2021 were responding to a runaway child report made by the parents. When they found the boy 2 days later, the report says he was shaking and very scared. The report says the boy told them he, out of all his siblings, was the only one that gets spanked, and he gets spanked with a jump rope and a leather belt. It goes on to say his mother recently had restrained him up against the wall and began yelling at him. When deputies found the boy, they say he kept changing his story about where he'd been and who with. Deputies writing, "At this time, we knew that he was lying." Deputies say the teen also had credit cards and other items that did not belong to him.
I just emailed the parents' attorney, Nellie King. She says the Arizona Department of Child Safety concluded the allegations of child abuse by the boy were unfounded. She says that finding is substantiated by sheriff's investigators who determined the boy's statements to them were untruthful. The parents claim the boy has a history of problems. They remain free on bond, while DCF has taken temporary custody of their other 3 children.
As part of their initial investigation, it says that the detective traveled to the previous residence, and while the address is redacted, my investigation says that that residence was in Arizona, and they spoke to someone It doesn't say the relationship. And they stated that the prior owners had a creepy room in their garage. The child told law enforcement that the longest he could remember being locked in his room was approximately 16 to 18 hours, and that he was provided with a bucket to go to the bathroom, stating that he had to use the bucket several times in the past, and he was made to dump it out in the backyard and then clean it out. His meals usually consisted of leftovers from whatever the rest of the family ate, and that he ate his meals in his bedroom. After the interview, the child asked if he could be arrested so he would not have to go back to that home. He said he would rather be in prison. And the officer asked him if he was having suicidal thoughts. He said yes, and he was ultimately Baker Acted. The Baker Act is a 72-hour mental health hold in Florida. It has different names in different states. Following this, members of the Special Victims Unit of the Florida Department of Children and Families, as well as one of the officers, went and spoke to the other children. The one that they spoke to, that's mentioned in this report, confirmed what this child had said. The sibling got very upset and said that they wanted to do the right thing. Based on the statements of those two children, they were able to obtain a search warrant for the Ring device that was located in the ceiling of this room. There were thousands of videos that showed the child repeatedly being locked in his room daily. And each day he was placed in his room, you could hear the door close and the deadbolt lock. In several of the videos, you could hear and see Redacted and Timothy Ferriter yelling at the child. In one video in particular, Redacted was locked in his room after being found to have stolen, in quotation marks, chocolate and cookies from the kitchen, despite being told he was not allowed to have them. This behavior resulted in the child having the covers removed from his mattress picked up and tossed against the wall, and Timothy grabbing the child against the arm and yelling at him. Each morning when Timothy greets the child, he asks him, "Is it dirty?" and points to the bucket the child has to use to relieve himself in the middle of the night that is kept in the corner of the bedroom. In one video, the child advises the bucket is dirty, and Timothy yells at him to go clean it out. Based on the information discussed so far, authorities issued an arrest warrant for Timothy Ferriter, and they charged him with 2 counts, and then later amended those counts to the ones that I listed earlier, as well as charging his wife as well. There was 30-something pages of documents and events leading up to this trial. I read as many of them as I could. A couple things that I found interesting that I wanted to share with you are things that were in the motion in limine. The state's first was to exclude a doctor. There's been a couple they want to exclude because the evaluations were subsequent to the defendant being charged, not a material fact. Another thing that they're trying to exclude is evidence from an incident that happened with the child after he was taken out of the parents' custody. I'm not sure if I said it or not, but all of the children were removed from their custody when this happened. And it appears that the defense is trying to bring in incidents that happened after the child was removed, which personally, I find it hard to attribute that to the child himself, because it could easily be attributed to the trauma of what the child went through living in that situation. Permit the defense to discuss professional interventions taken with the child not related to his or her diagnosis or specific treatment interventions by facilities after his removal from the home. Preclude the state from arguing the child's room was a box or cage. Exclude all statements from co-defendant, Tracy, the mom. Exclude all evidence that the co-defendant altering items in the child's room. Preclude the state from utilizing the term target child. Preclude Redacted from testifying about her thoughts, beliefs, and otherwise speculation regarding the acts of her parents. Okay, so one of the siblings. They don't want one of the siblings to comment on what she believes her parents were doing towards the child. And they also want to prohibit the child, or two of them, from using a therapy dog during testimony. Like, why? Why does that matter? And also admonish witnesses that they can only state facts that they personally witnessed, not speculation or embellish. As I mentioned before, there was a lot going on pre-trial. I can't remember if I said it specifically or not, but they did determine that the parents would be tried individually for these charges. Further, the judge ordered that the evidence that was gathered from the incident in Arizona will be allowed in, and this could be beneficial for the Ferriters, as the Arizona CPS and law enforcement ultimately determined that they believed the boy was lying. This was due to him having stolen some money from, I believe, a teacher or a tutor, and several other things, although his statements in Arizona were strikingly similar to his statements here in Florida, so that could be used against them. We'll have to wait and see. The state planned to present evidence from the family's home computer that was showing a search history that was potentially damaging to the Ferriters. However, they're claiming that their email was hacked and that one of the children actually took a video of themselves going through the search history on the computer, and they're, I think, challenging its authenticity.
It's a story from our area that made national headlines. Jupiter parents accused of locking their teenage son in a box for hours at a time. Today, that couple was back in court with their lawyers who were trying to get evidence thrown out and a prosecuting attorney removed from the case. WPTV's Cameron Eppinger in the courtroom. He joins us with what happened today.
I'm Cameron Eppinger. The Jupiter couple accused of locking up their 14-year-old inside a box in their garage was back inside the Palm Beach County Courthouse today, where their lawyers tried to get evidence thrown out and a prosecuting attorney removed from the case. Inside the courtroom, Timothy Ferriter and his wife Tracy sat side by side holding hands as the judge heard from their attorney.
Motion for protective order, motion for production of all communications regarding evidence unlawfully obtained.
The couple from Jupiter face false imprisonment charges and aggravated child abuse for allegedly keeping their 14-year-old locked up in a box inside their garage. In court today, their lawyer, Nellie King, tried to get potential evidence thrown out.
It's the fact that they unlawfully obtained it through one of the witnesses who is a kid.
The evidence in question was a minute-long video of the parents' search history. King claims her client's email account was hacked by at least one of their own children, who then sent the video to the Department of Children and Families and a lawyer with the Foster's Children Project Legal Aid.
When you watch the video, they scroll through the same searches that seem to be of import to the person who's obtained this over and over again and then highlight them.
The defense also asked to have that lawyer removed from the case, an issue that the judge said should be taken up in dependency court instead of criminal court.
You're asking to suppress something for the state to use that they don't have, that they've never seen, which takes me back to what I said at the beginning. This seems premature to me.
In the end, the judge ultimately denied the motions, citing the defense was unable to prove the children were told to hack their parents' computers.
At this stage, you've not been able to tie that link, to connect the dot.
Now, both the state and the defense are due back in court later this month on April 27th. At the courthouse, I'm Cameron Eppinger.
Finally, within the week leading up to the trial, the father was presented a plea deal that would allow him to serve only 2 years in prison versus the 40 years he's facing if this goes to trial. He rejected this plea deal. That's a big reject. So he must have a good reason.
Was it a case of child neglect or bad parenting? Was it punishment or simply protection? Defense attorney Priya Murad and the state will have a complex case in front of them on Friday to prove whether or not Tim Ferriter should be found guilty on charges of child abuse and false imprisonment. Both will be tried separately.
You swear to tell the truth, whole truth, and nothing but the truth, so help you God.
I do. In a pretrial hearing Tuesday, Tim Ferriter rejected a plea deal by the state, 24 months and 5 years probation. He now faces 35 years and possibly more. His attorney contends the child was a, quote, medically complex child, and the alleged box was, quote, a room used for monitoring. The defense intends to show a pattern of troubled behavior, which at the onset of the case showed dangerous and disturbing propensities, including attachment disorders. DCF removed the child and 3 other children from the home. It is now up to a jury to decide the fate of the parents.
The judge presiding over this case is the Honorable Howard Coates, Jr., who is part of the 15th Judicial Circuit in Palm Beach County, Florida, Division 5. The morning before trial started, Judge Coates heard the defense and prosecution, further arguments over what evidence should and should not be admitted. There is quite a bit of disagreement over what images should and should not be portrayed and what can be derived from the images that are being shown, as well as the videos. So here is the morning before trial and Judge Coates ruling on the issue.
Opening statement, the state objects to it. And it's a 5-minute video that includes a lot of photographs that the state montages, videos that the state doesn't believe will come into evidence. They're not relevant, they're prejudicial. And so we would object to them being shown to the jury at this time, prior to Your Honor making an evidentiary ruling.
All right. I can show it to the court.
What's the basis, and how does it not amount to just good character type evidence?
So, Judge,
that's the primary concern I had coming out of the hearing yesterday, when you told me that you have 200 photos.
That's not, I understand that, Your Honor, but this video is only 5 minutes. I would say the second half of it includes ring videos that were disclosed by the state in discovery. So the beginning of the video includes some family photos and videos. And the reason it doesn't amount to good character evidence is there's an intent element here.
I understand that, but it doesn't mean you can put in evidence of good character to negate an intent element of a criminal offense. So
Judge, it is kind of different here because the issue is parenting, right? And they're trying to say that there's a time frame in which, and they're going to show limited videos of the relationship between parents and children that say this is abusive because of the way in which that this particular conduct.
Where's your client?
I think Mr. Wahed is getting him, Judge. I apologize.
All right, we should have him present for this argument. All right, so the court knows that Mr. Ferriter is now present. All right, so go ahead, Ms. Moran.
So, Judge, it's a short video. I don't believe that it's cumulative. I'm happy to show it to the court. It's primarily things from after Ronan was 10 years old, and it's only for opening. And again, I would ask the court to consider that the second half of it is just ring videos that are disclosed in discovery. So the fact that the state is able to play videos of him in a room or doing things that they deem abusive, the only way for us to counter that is to offer context as to what the rest of his life was like. Otherwise, it's just them yelling at him or putting him in a room, right? Like any parent. If anyone's worst parenting hits were recorded on video, I think everyone would seem abusive. So we have to be able to offer some level of context. I understand that the court can sort of tailor that so that it's not cumulative.
The most pious individual in the world could be a great, upstanding, moral individual, but if that individual, despite his piety or great character, commits a single act that results in a criminal offense, my understanding of the law is that evidence of piety and great character doesn't come in to negate the criminal offense that has occurred. So how is this different from that?
Because that piety is irrelevant to, if someone shoots somebody and murders them, the fact that they served food at the food bank is irrelevant. In this case, we are being asked to make, or the jury is being asked to make a decision about whether or not a parent had the intent to commit abuse and whether or not that abuse was already committed. So it's not just good character evidence. It ties into the facts because this relationship is relevant. It's like,
so let me give you some context, and I'll give you an opportunity to make your argument. Let's say you want to show pictures. Haven't seen them yet, but you want to show pictures of the defendant and his son, him taking his son to a basketball game or soccer game, him playing catch with his son, doing father-son types of things. How is that relevant to the issue of whether he's guilty or has committed the criminal offenses of which he's alleged to have committed in this case?
Because as the jury said yesterday during our discussion of criminal intent, there's no, if Mr. Ferriter does not testify, right, the only way to determine his intent is his conduct. And if the only person that's permitted to admit conduct is the state, then we have no ability to negate what that intent is and show, no, this is a family with ups and downs, and there were issues that this child was facing. But that doesn't mean he was unloved or uncared for.
But it doesn't matter. It doesn't matter.
It does matter.
How does it matter? It doesn't matter whether he's loved or unloved. If the criminal offense is false, let's deal with false imprisonment for instance. If the criminal offense is false imprisonment, and the allegations are that he placed his son in improper confinement that amounted to alleged false imprisonment, doesn't matter whether he loved his son or not. That's irrelevant. It's did he stick his son in a facility or structure that amounts to, under the law, false imprisonment? That's the issue, isn't it?
So I think that's different for the false imprisonment charge than it is the aggravated and the neglect. So the false imprisonment charge is sort of a different, I mean, I still think there's an intent element there, but I understand why there's a little bit more clarity as to what constitutes false imprisonment. But what constitutes child abuse is different, because there's a lot of stuff that parents are allowed to do that does not constitute child abuse, unlike false imprisonment where there's a lot more clarity. And there is a maliciousness element. The state spent an extensive amount of time talking to the jury about what does maliciousness mean to you. If all they see are the state's videos, that's what they're gonna think.
All right.
I would like the court to view the video. It's 5 minutes. I need to put it in the record anyway. And if the court is not inclined to permit me to play any of it, I would ask that the court permit me to play the videos that were disclosed in discovery by the state during the course of time.
Disclosed, counsel, disclosed in discovery is not the barometer or the measure by which you're allowed to present it to the jury. There's a lot of stuff disclosed during discovery that is not admissible at the trial. So let me make this simple. If there are things in this video that are not coming into evidence at trial, I'm not going to allow you to show it. But do you believe you're going to be able to overcome the objection? Because I assume there's going to be an objection to these things coming into trial. And if you're going to show them evidence that I know that's not going to come in during the trial, I'm not going to allow it in opening statements.
So my position, based on the argument that I'm presenting to the court, is that it should be admitted. And so I think the court needs to view it and make a pretrial ruling. And I know that delays the jury. It could either now or bring the jury, do the instruction, state do their opening, and then give them a short break. Because you know it's a 5-minute video. I'm happy to email it to Your Honor's judicial assistant so the court can even watch it in the back. And then perhaps there are portions of the video that the court would allow. Because I understand what the court is saying, that just because, of course, something's in discovery, we depose on all sorts of stuff and it's speculative, it doesn't come into evidence. However, in this particular situation, there's a 4-week time period, that's it, within which the state is saying that certain conduct happened that amounts to aggravated child abuse, child neglect, and false imprisonment. And so there are other videos during the course of that show that there is malicious intent. So if we do not have the ability within reason, and I understand if the court makes a ruling that too much of it is cumulative, but if we don't have any shot at explaining, then
So your back to my hypothetical example. Your client takes his son to the basketball game on a Saturday afternoon. Great day. They're laughing, smiling, having a great old time. Brings him back home and puts him in, allegedly, in this structure, locks the key from the outside. I'm concerned that you're kind of going down a path of saying that taking the child to the game and doing the father-son thing somehow justifies or explains putting the son allegedly in the cage, and that I can't connect those dots.
No, Judge, that's not the defense.
All right, so what is the relevancy of it then?
Well, first, I think that the issue is the court's understanding of the room and how it was utilized. So first and foremost, you know, the defense's position is that it was utilized primarily for supervision. In his own deposition, Ronan said it wasn't locked all the time. This is mainly in the evenings when he couldn't be supervised. And we're still working on putting it all together, but that will be presented in the defense case in chief based on the videos provided in discovery, and I do think that's relevant. So how can a jury make a determination about the relationship between a parent and a child without some context as to what the relation? It's like a self-defense case. You have to have context in order to explain conduct.
And they got to do it based on admissible evidence. If there's not admissible evidence, then they may not be able to make that connection. But it still boils down to both sides having to work with what is admissible in this case. And that's my job as the judge, to ensure that what comes in is admissible and what's presented to them is admissible. And I have significant concerns that what may be in this video is not admissible. Here's what I'm going to do. I'm not going to spend any more time on this. Email it to my chambers right now. I'll review it, and then I'll come back out and announce a ruling. The court's going to be in recess for 10 minutes for me to review this video.
Mr. Wahed, he has an argument to
add.
add. I
just want to add one thing, Judge. First.
All right, so let me make sure that we have a proper protocol here going forward. One spokesman per side per issue. So if you take the lead, Ms. Murad, I'm only going to hear from you. I have no problem with Mr. Wahed taking the lead, and I'll hear only from him. But I don't want to have this double teaming, and so you know my procedure. I will go ahead and hear your comment at this point because I didn't advise you of that prior to this instance. But going forward, I'm only going to hear from one side, one spokesman for each issue. That means you can alternate whatever issues you want to discuss. All right, go ahead, Mr. Wahed.
Thank you, Judge. First, in terms of admissible evidence, you definitely have RF who's going to be able to speak to those photographs. So that evidence would be admissible at the very least through RF. So he's aware of those things. He was asked about some of those things in deposition. He admits those things. These pictures would be admissible through RF. Second, at least most of them. Second, because at some point he was too young. So obviously the ones where he's too young, he won't recall. Second, our defense, which is the affirmative parental defense, there's an issue of reasonableness, of reasonable parenting. And that requires context. It requires the jury to understand, and just for the court's information, what's going to come out through both a state expert and a defense expert is the escalating history of the family dealing with RF and his mental health issues throughout the course of his life. And it's important because the state is essentially putting forth that he is in this room all of the time, or the majority of the time when he's not in school. And that has to be rebutted. This evidence rebuts that.
Well, I'm not sure I agree with you. I haven't said yet that I would knock out photos of perhaps the parents and RF going to a psychiatrist office, for instance, or going to a mental health facility. But that would be something that might be admissible, and it might be relevant to the response and the efforts of the parents to deal with the issues that they're having with their child. I get that. I get the strategy. But just simply showing a picture of the parents and the children having a good time at some point, to me, is not relevant to the specific issues that I have to decide in this case from an evidentiary standpoint. I'm not going to hear any further argument. Go ahead and email it to my chambers, and I will take a recess for 10 minutes. When I come back, I'll announce a ruling. All right, court's in recess.
Court's in brief recess.
The proposed video of the defense in camera. Court sustains the objection of the state. All right, anything else I need to address prior to the opening statements?
And that brings us up to opening statements in this very disturbing case. As I said before, I am going to trim up the daily court proceedings to get out all of the dead space, all of the white noise while they're having bench conferences, all of the jury shuffling in and out where you're staring at the ceiling or the seal, and then I'm going to post it. It's probably going to be the following day, so you're going to be a day behind. If you want to watch it live, you're more than welcome to. But if you want to watch another trial during the day, I'm going to post this in the evening after most of the daily trials are done so that people are able to watch both if they'd like. Okay, everybody, have a great day.